What should you expect if you need to consult with an attorney? I'm Dan Ringer, and we'll talk about dealing with lawyers right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
Knowing what to expect is important in any relationship. So what should you expect when dealing with a lawyer? My guest is attorney and emeritus West Virginia University law professor, Jack Bowman. Jack, thanks for coming in.
Thanks, Dan. Nice to be here.
Someone who has never enjoyed dealing with a lawyer before needs to consult with one. What should they expect?
Well, basically, they need to expect that the lawyer is going to be on their side, that he or she will be someone who will help them through what may be a difficult and confusing process.
Well, if I'm going to be on your side as an attorney, does that mean that I have to agree with you?
No, not necessarily. In fact, to be on your side basically means that a lawyer should be willing to tell a client what he or she doesn't want to hear. That's one of the reasons you'll hire a lawyer, to give you advice that you may not like, and to give you advice that will help you through the process. A lawyer is a fiduciary, which is the highest obligation in the law. And the obligation of a lawyer as a fiduciary toward his principal or her principal, the client, is to represent that client to the best of your ability, and even, although it runs contrary to human nature, to place the client's interests before your own interests. So the lawyer's obligation is to put the client's interests in front of the lawyer's interest in every instance.
I would understand that to mean then if you, your wife, your children, and your client are on fire and you have a glass of water, you have to throw it on the client first.
Absolutely, absolutely. Your obligation is to the client, and whoever the client may be, and sometimes that's not always very clear, by the way, but once you know who the client is and where your obligations are, you have to represent them to the best of your ability, which means you put their interests ahead of yours. I can't, for example, write a will for you and slip in a little paragraph that leaves something to me. Cannot do that. It's absolutely forbidden. You can pay me a fee for writing the will, a fee to which we've negotiated and agreed on, but I can't take advantage of you in any way.
So even if you say to me, I want to give you my horse or my car or $5, just put that in the will. We'll make sure that you can't do that.
Unless you're related to the client. So if, for example, my aunt were to say, I want to leave you some money, I could write her will. Now, I'd probably be a fool for doing it if I had a cousin who maybe wouldn't like that. But unless there's a relationship, the law is very clear, and I have the rules of professional conduct here, that you can't write a will for anyone leaving anything to you or your family as a lawyer or the lawyer's family unless there's a relationship.
And we have had that
family
tested.
Relationship.
And we have had that tested, and the courts say that's what the rule says.
Oh yes, we disbarred a lawyer some years ago for doing just that.
Well, when the client comes in, what should they expect? You're talking with this lawyer, and there's always the question of, is the lawyer going to represent you? How do you talk to this lawyer to make that relationship or to form that relationship?
Well, I think you have an obligation as a client to be candid with a lawyer. You have the right to say, look, is anything I'm going to discuss with you confidential? And the answer from the lawyer's viewpoint is yes. Whether we form an attorney-client relationship or not, what you tell me is confidential.
What's the test for that? If I'm walking down the street and I see you and say, hi, Jack, how are you? That's not an attorney-client conversation.
No, the attorney-client relationship arises when I agree as a lawyer to take you on as a client, and you agree as a client to hire me. That's when it arises. But before that, when you come to me to see me about the possibility of hiring me as a lawyer, there's an obligation of confidentiality. For example, you come to me and you say, Jack, I want you to represent me in this lawsuit. And we talk for a while, and I say, Dan, I can't do it. I just don't want to get involved in this. And then you go to another lawyer, and then the person you're suing comes to me and says, hey, I'd like you to represent me against Dan Ringer. I can't take it, that case, because I've already talked with you. We've already had a confidential relationship, and I can't now be against you, even though we never entered into an attorney-client relationship formally. We had that pre-client relationship where confidentiality is assured.
One of the things that often happens to a lawyer practicing in West Virginia, and probably any place else, is that people will call by phone and say, I'd like to ask a question, or I just have a few questions, simple questions. Most lawyers will not talk to you on the phone about your situation.
And rightly so, because first of all, you call and ask me a question, and it'll probably be very simplified, and then I give you a very simple answer, and it turns out your problem is much more complicated than that, and the answer I gave you, based on the complications in your question, is wrong, and suddenly I could be guilty of malpractice.
Yeah, the monkey that you called to complain about may in fact be a gorilla.
That's right.
And if I say monkeys are easy to take care of,
right,
do thus and so, but gorillas, it might be a completely different thing.
You asked me about what you expect. Well, you have the right to expect that your lawyer be competent. That's an absolute, in fact, that's the first rule. You're required to be competent. You have the right to expect that the lawyer will, you and the lawyer will agree to a fee, and the lawyer cannot raise that on you without your knowledge and consent. You have the right to expect that the lawyer will be diligent, that he'll keep up with the case. You have the right to expect the lawyer will communicate with you, let you know what's going on. You have a right to expect that the lawyer will maintain absolute confidentiality, except for those things that you say, you may reveal that, or a court may, under one or two exceptions, pry out of you.
One of the problems that I have seen, I have experienced, I have heard about, is the client's ability to communicate all of the important aspects, all the important information in the matter to the attorney. I saw a statistic last night. The West Virginia Department of Education estimated, or has determined by whatever mechanism, that the lowest, I'm going to call it functional literacy rate, that is, people who can just barely understand the things that they read, the things that are told to them. The lowest rate in West Virginia by county is about 14%. That means that about 14% of the population has a great deal of difficulty understanding pretty much anything you convey to them. How in the world can a client come in and convey information to an attorney who has at least 7 years of college to practice law, 3 years of law school, 4 years of undergraduate school, and how can the attorney convey the information to the client that the client needs to know?
Well, it's very difficult. And one of the problems we have in the attorney-client relationship establishment is that clients come in and they tell the story, and the story usually isn't complete. They tell what they want the lawyer to know. I'd rather you didn't know I had 2 drinks before this accident. I'd rather you didn't know this or that. And
it was always only 2 drinks.
And that's right. And I tell you, well, 2 beers, actually.
Yeah.
And I tell you the story, and I don't expect you to probe, but your job is to probe and start questioning me. And I used to tell clients when I was in the military handling criminal cases, look, I don't care whether you're guilty or not. That's not my job. I want to know what happened, and I can best represent you if you tell me the whole story and the truth. And then you just have to work it out with the client, and the client has to come to understand that you're on their side. And once that understanding's developed, it's been my experience that suddenly they tell you things that they wouldn't otherwise tell you. And even if you have not much education, and that doesn't mean you're not very smart, but even if you're not very smart, however well educated you may be, the fact is that once you establish this relationship, it can go a long way. Once they understand that you're going to keep everything confidential, that you're not going to take advantage of them, that you really are on their side, then it makes it a lot easier.
One of the most frequent questions, though, is especially in criminal cases that a lawyer will hear, is they talk to the client for the first or maybe second time, and they start probing and testing what the client is saying, and the client will look at them and say, whose side are you on anyway?
And you have to explain to them, I'm on your side, but I have to know the story. I represented a client by appointment in Kanawha County 35 years ago, I guess, and it was a breaking and entering, and they had arrested this client in a house full of stolen goods. And he claimed that that night he had not been involved in the breaking and entering for which he was charged, but that there was another witness out there who could confirm it. And I kept saying to him, who is this other witness? And he was vague about it. And I told him, I'm going to spend the rest of the next 2 weeks looking for that witness when I could be doing other things to represent you. But unless you tell me the truth, he said, I'm telling you the truth. So I had to accept my client. I accept, you accept at a point, a lawyer will accept that the client's telling the truth. And you say, look, I'm going to believe what you tell me, and if you're lying to me, it hurts your case. So you tell me, I'll go out. I was in and out of every bar in Kanawha County for 2 weeks trying to find this witness that I didn't really believe existed, but didn't know for sure, and he never turned up.
I have always told my clients, after I say, tell me completely, absolutely, everything you know about what happened, then I'll tell them I can only believe about 80% of what anybody tells me. You may be trying to be absolutely, technically correct, totally truthful about what you're saying, but you're filtering it through your eyes and through your mind, and that colors it.
Sure, absolutely. Always does. And that's human nature. And that's why it takes a little bit of a dance to get the client to understand, even for writing a will. It takes a little bit of a dance for them to understand that you're there with them and you're going to give them advice they don't want to hear, that you're going to be on their side. It takes a while to establish that.
We're talking about what you should expect when dealing with a lawyer. My guest is attorney and emeritus West Virginia University law professor Jack Bowman. I'm Dan Ringer, and this is The Law Works. Even when writing a will, and I've seen this over and over and over again, people will come in and say, I just want you to write me a simple will. How much will that cost? And my response has always been to that, I don't know. Writing a simple will is actually a really simple matter, take 1, maybe 2 hours. The trick is in learning, coming to understand that a simple will is really what you need, because invariably people say, I want to leave it all to my spouse except.
Well, you've hit the nail on the head, because actually what you need to find out is a simple will what you need? And what do you mean by simple will? And if it's not what you need, what do you need? That's why people say, well, lawyers, they just get in the way. Well, with the technicalities. The fact is the law is full of technicalities. And if, for example, I have children by a previous marriage that my wife may not know about, those children may have some rights against my estate, and we have to deal with that either in or out of the will. It has to be solved. And you really need to have the full story. And coming in and saying, what does this cost? I feel very strongly that the obligation lawyers have to be reasonable with their fees. And I think that where it can be done without using an expensive lawyer, that's fine. If clients can do their own work, fine, hallelujah. But the fact is that what seems simple to a client may in fact be very complicated, may have some wrinkles in it they don't know about. And one of the reasons you come to a lawyer is because they're going to say to you, oh, wait a minute, you have a problem here that you didn't realize. For example, I may be one of 3 siblings who has an interest in a farm. And depending on how it came to us, let's say by our mother's will, there may be obligations that I have toward descendants of my other siblings that I'm not aware of. I think, well, if I'm the sole survivor, then it's all mine. Well, maybe it is, maybe it's not. And we have to look at the documents to find out.
One of the most complex situations regarding estates and wills that I've seen in recent times, some folks came to see me and said, our mother left us the farm. I said, that's great. Who was your mother? And they mentioned a name. I said, I know that person. Okay, what do you want to do? We want to sell the farm. So I went out and decided before I did much of anything else, I wanted to prove the title to the farm to make sure that they really had it. Typically, the seller doesn't have to do that, but sometimes, especially when you're dealing with family property, it's a good idea to take a look at that. I found out that their mother didn't leave them the farm, that their mother didn't own the farm. She owned about 1/3 of the farm, that there were 2 other interests out there. And by the way, your grandfather, who died 40 or 50 years ago, his estate's still open. And we've never finished that. And that thing turned into a swamp.
But it's a good thing they came to you, because you can drain that swamp. You can solve that problem.
And it's never easier tomorrow than it is today.
No.
Worked out okay. but it took a lot of time to do it.
I would say also that it's important that you feel comfortable with your lawyer. And I tell lawyers it's important that you feel comfortable with your client. And if I, for whatever reason, feel uncomfortable with you as a client, it may be unfair on my part, but I can say, Dan, I'm sorry, I just don't want to get involved in this case. By the same token, you have the right, if you don't feel comfortable with a lawyer, then you have the right to say, I'm sorry, I don't think I want you to represent me. A client, by the way, can fire a lawyer for any reason or for no reason at all. A lawyer cannot fire a client. Once you've established the attorney-client relationship, you can't break that relationship without the consent of the client or an order of court.
In fact, that's why it's a good idea to have a contract, an agreement between the client and the attorney that outlines some of these things. And it may be so simple as to say, for the lawyer, and it's probably not a bad idea to put this in the agreement, if I catch you deliberately misrepresenting the facts of the situation, I have the right to withdraw.
Sure.
And you won't oppose that.
I believe in having a contract. Anytime you have an agreement between two people over matters that involve anything at all of significance, write it down. That way, you don't get the fight that you may get if it's not written down. So have it laid out. I used to tell my class in contracts that an oral contract is not worth the paper it's not written on, and I believe that. I think if there's any question, if we're going to enter into business together, write it down, get it down. That way, we don't fall out. Because you say, well, that's what it says, and I say, well, that's what it says, and then we don't follow it. Otherwise, I say, well, no, here's what I thought, and you say, here's what I thought, and we fall out.
There is a great tendency or great push these days to say that legal representation ought to be done on a flat fee basis as opposed to an hourly basis. And we're not talking about contingent fees in personal injury lawsuits. That's a different matter. What are your thoughts on that?
I think the day of the hourly fee is dying. The idea that you come to me and I say, this is my hourly rate. Can't tell you, by the way, how many hours it's going to take, but this is what I charge, and if you're going to hire me, I'm going to represent you at this X dollars per hour, and well, we'll just see how long it takes. And those days are gone. I think more and more successful lawyers are going to have to be looking at, okay, this is this type situation, and it's likely to run up this kind of a fee. And I look at you and we talk and I say, well, in my mind's eye, this is probably going to be about an $8,000 to $10,000 matter. And so I say to you, Dan, I'm willing to represent you at an hourly rate of X dollars, not to exceed $12,000. I think that'll give me a little cushion. And so I say $12,000, and you say fine. And then when it actually comes in that it costs $9,000, I send you the bill for $9,000. You're happy, and I'm happy. I think more and more lawyers are going to have to be able to estimate and offer some kind of a fee limitation.
That's an attractive idea. The kinds of fees I've seen people talk about are, I want this divorce for $500 or for $1,000 or something like that, and I just don't see any way to make that work. Think about that for a second while I reintroduce this. We're talking about what to expect when dealing with a lawyer. My guest is attorney and Emeritus West Virginia University law professor Jack Bowman. I'm Dan Ringer, and this is The Law Works. And I say that my primary concern is that somebody says, I want this service for this fee, and you really can't say, I have to do A, B, C, and D. Too much legal representation is reactive to what the other side is doing or not doing. You calculate a flat fee, and what the lawyer does is presumes that everything goes wrong and everything is the worst case situation, and if you're going to pay it as a flat fee, you're probably going to pay more than you ought to, because the lawyer's going to design that to protect himself.
Well, flat fee, the problem is, one of the problems with the flat fee is they start comparing. Well, I can get a divorce down the street for $145. You're offering me $200 for an uncontested divorce, and so I go down the street. The fact is, the lawyer runs a great risk. I offer this divorce or this will for X dollars, and it turns out it's a nightmare like you had in the situation you gave me, and suddenly I find myself backing up and losing all kinds of money on this matter, and I've got to make that up somewhere. On the other hand, if I estimate on the outside edge and say, well, I'll do it for $1,000 and it only takes me $300 worth of time, then I've taken advantage of you. So the flat fee has some real dangers. I do think that lawyers are going to have to make some kind of a cap and say, look, I can do it for this unless certain things develop. And along the way, you talk, look, here it is, here's where we are, here's what's happened because of what you told me or what you didn't tell me, and I cannot continue, and we renegotiate. But again, the client has the right to know what the fee is and to agree to it. I can't raise a fee on you without your knowledge and consent.
Even if it's an hourly fee, you're tied into that hourly fee until there's an agreement that you either aren't or that it's going to change.
That's right.
If you do want to hire your lawyer and you are in court, what does it take to do that?
Well, if you're in court, the judge is going to have to let the lawyer off. You may fire the lawyer. The judge may not let the lawyer out. If you're not in court, you can just write a letter to the lawyer, say, I'm no longer going to retain you as my lawyer, and please return my papers to me. And the lawyer has the right to be paid for the work he or she has done up to then.
Well, I'm not going to give you your file back until you pay me.
Well, unfortunately, the file is yours, and I can't use that as a stick over your head. I can't do that. I've often thought that's unfortunate because, as a matter of fact, it's unfair.
I've thought that from time to time.
On the lawyer's part, but the fact is, I can't say, no file back until you pay me my fee. We have to work out the fee. Here's your file.
So the situation is, this is your file. You say, I'm done with you. I don't want you to represent me anymore. The only response I can give is, here's your file, and here's the bill for what I've done.
You have a right to take certain papers out of the file. If I had an evaluation of you, I think this guy's a nutcase, and I'm concerned he's lying to me, I can take that out of the file. I can take out certain personal observations I have, and you don't see those. Otherwise, all the work I've done for you, you're entitled to.
Does that include the notes and the research and all of that?
Yes, it includes the notes and research, so long, again, as the notes aren't notes I think may be harmful.
So things that I might want to remember about you is, the guy's weird. He wears a bow tie, or he dresses funny.
Well, I think that would be a sign of intelligence, but we won't go there.
Well, the bow tie would be, but my observation that you're weird because of that, that's my personal observation.
You can keep that, that's right. Well, the most common thing is, I'm really kind of scared of this guy. I think he may go off his rocker and kill somebody. Well, that's something I can pull out of the file. I don't have to give it to you.
Then why are you representing him? If you
Well, that's another issue. That's another issue. Probably I backed into it. I took the case. I didn't feel comfortable with the guy, but gosh, the fee looked good and the case looked good, and so I took the case, and now I want out. And fortunately, he's firing me. But that's another issue. Why did I take the case? And again, I keep telling lawyers, if you feel uncomfortable about the client, don't take the case.
But you have to come to that conclusion early on.
Oh, early, very first interview, you say, look, I'm sorry, for lots of reasons, I just can't get involved. But you understand you are involved to the point you cannot now come in on the other side.
One of the things that happens in practice is you get this late Friday afternoon phone call, and you actually find yourself on the phone with the prospective client, and the prospective client says, are you going to represent me?
And you can't maybe answer that question. Maybe you can. Oh, sure, I'll be happy to. The worst thing that happens is a lawyer's Friday afternoon, and it's at 3 o'clock, and the courthouse closes at 4:30, and the statute of limitations runs at midnight tonight, and they want you to represent them.
And the statute of limitations means there is a deadline in most all situations by which you must file a lawsuit if you are expecting to recover something from the other person through a lawsuit. And I can't tell you right now what it may be in your circumstances, because there are more statutes of limitations of different lengths.
But let's say this is a simple one. It's an automobile accident. There's a 2-year statute of limitations. The accident happened 2 years ago today. At midnight tonight, the statute runs. You either sue or you forever give up your right to sue, and they can't get any other lawyer to represent them, and there you are, it's 3 o'clock, and they want you to file a complaint for them. What do you do?
What do? I say, I'm really sorry you waited this long to call me. I can't help you.
Absolutely, absolutely. You have no obligation, moral or otherwise, to take a case because you are the, quote, last lawyer in town, quote, or the time is running. You have no obligation to take that matter. But that happens all the time. In fact, I was on the disciplinary board back when it was called the Ethics Committee for 11 years, the lawyer disciplinary board. And one of the interesting cases we had came up because at lunch on the last day the statute was running, a lawyer was approached by an old friend, and feeling sorry for the old friend, he took the case, and it turned out to be a turkey, and he was before the disciplinary board because of something he had not done. And he was then crying, saying, I shouldn't have taken it.
And I had a case similar to that where the client came in and said, this is what happened to me, and the lawyer talked to the client and then filed the lawsuit against the wrong entity, where with just a little more time, a little more work, he could have identified the right entity, didn't, he blew it. And even though he only had 25 seconds to figure it out, he took on the case, agreed to try to figure it out, and didn't.
And probably was sued for malpractice, and his insurer upped up the money.
Exactly. Professor Emeritus Jack Bowman, thank you, sir, for coming and being with us.
Thank you for having me.
Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. If you have a legal problem and want to know if you need a lawyer, you can discuss your problem with a lawyer by calling 1-800-642-3617 Tuesday evenings from 6 to 8 p.m. That's 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.